Thank you all for having me out here today. Just quick on my background. I'm actually a student at UC Berkeley Law School right now. I've done a bunch of work in the privacy space. I've worked on behalf of the Electronic Frontier Foundation. I spent most of my time at Berkeley working in the Samuelson Clinic for Law, Technology, and Public Policy. So it's a public interest clinic whose sole goal is to focus on public interest issues in the technology space. That's a lot of privacy issues, free speech as it relates to the internet, copyright, kind of a whole range of issues. I've spent most of my time there working on social networking website issues, so working with a public defender's office on the way in which lawyers are allowed to legally and ethically go onto social networks to collect information about you that they're going to then use in legal cases. I've also worked with the EFF, the Electronic Frontier Foundation, on a recent suit against the federal government to try and determine how the federal government is using social networking websites. And I'm currently involved in a project looking at privacy as it relates to the smart grid. So what I wanted to kind of walk you through today is kind of a bunch of issues that really excite me, that are kind of at the cutting edge of where technology is conflicting with privacy and conflicting with the law. So to start out, I'm going to go a brief overview of some kind of high-level privacy concepts that will hopefully frame our conversation. And then I want to talk about the Fourth Amendment, which is what prevents the government from coming into your home, taking a look at all of your private documents. It's probably my favorite area of the law. Then I want to talk a little bit about the government on social networks, privacy in public spaces. This may seem like an odd concept, but particularly in the era of social networks, it's really important to think about our contextual privacy and the different ways we inspect our information to be used. And then re-identification, and then some new frontiers. So how do we think about protecting privacy? And I think this is really important for all of you being computer scientists, because you're on the ground level of this. So one of the most, and I kind of want you to think about this as we go through the presentation. I'm going to raise a whole bunch of issues related to privacy and technology, and some of these can be solved in various different ways. The most basic is by regulation. We can have the government come in, pass a law saying, companies, you must do this, or law enforcement, you must do this to respect privacy. Another way to do it is privacy by design. And this is where all of you come in. How are you building your databases? How are you building your information systems to protect privacy? Is that something you are taking into account? And companies are realizing more and more that this is actually an important business issue. Facebook has gotten slammed recently. Google just got slammed for Buzz, for not thinking through all the privacy ramifications. And they lost huge numbers of users because they didn't think about it. And so one of the most basic issues is, as you're designing these systems, what information are you exposing? And also more fundamentally, what information are you collecting? If you don't have the data, it can't be lost. It can't be collected by law enforcement. You can't be liable for it if you don't collect it in the first place. And then there's privacy-enhancing technology. So once we have a system in place that has a privacy risk, we can put protections in place on top of that to protect our privacy. For example, on my web browser, I have a plugin that blocks all JavaScript. I have a Flash blocker. I have a plugin that deletes all my cookies whenever I close my browser. So those are all privacy-enhancing technologies I've put on top of my browser to try and protect my identity as I traverse the internet. Encryption could be another example. And then there's actually privacy by transparency or oversight. And this relates somewhat to social norms. You all may recall during the elections that there was a brief scandal where people had looked at candidate Obama, candidate Clinton, and candidate McCain's passports. People at the State Department had brought up their passports and had taken a look at it. And those people were all fired because there were audit logs within the State Department that recorded who was accessing information. And so the organization itself was enabled to enforce privacy regulation by having some transparency into what was going on. And then as you're developing privacy restrictions, you want to think about, who are you trying to protect against? Are you most worried about the government? Are you worried about companies, about marketers? Are you worried about your insurance company getting a hold of this data and denying you coverage because of something they found out? Or are you worried about bad actors, criminals, identity fraud? So just some high-level basics on privacy. You might be surprised to know privacy is not in our Constitution anywhere. It's not in the Bill of Rights. It has been read into what some Supreme Court justices have termed the penumbra of the Bill of Rights. So they've looked at the First Amendment, the Third Amendment, Fourth and 14th, and have decided that in order to protect all of those essential rights, that privacy relates to it. And so there's a long stream of decisions which are essentially based on the right to privacy, and it's a right to privacy that are inferred from a number of different amendments. The state constitutions are a little bit better. You'll be happy to know the California Constitution, we do have a right to privacy in this state, but it's obviously limited. So then what else is protecting our privacy besides the constitutions? There's a whole bunch of laws that protect it. The Electronic Communications Privacy Act is the most important one. And you might notice some of the dates up here and when these acts were passed. 1986. That's a long time ago for the act that's protecting your privacy on Facebook and Google and on Gmail. 86 was the heyday when PCs were just launching and electronic bulletin boards were the new hot thing. They couldn't really comprehend all the technologies that exist now. So the rules that have been written into that have been applied to these new companies, but in kind of crude and inexact ways. So they need to be re-examined. So the Fourth Amendment protects the right of the people to be secure in their persons, houses, papers, effects against unreasonable searches and seizures. And really this was envisioned as a way to make your home your castle, at least as far as law enforcement was concerned. The law, the government cannot come into your home. They can't rifle through all your private papers. They need to get explicit permission from a judge in order to do that. So without a warrant, it's presumptively unreasonable to go into someone's home to look at their papers. But there's a number of broad exceptions. And first I'm going to talk about kind of where these exceptions came from, and then I'm going to look at how they apply in the technological world. Because you'll see all these exceptions make sense in the offline world. When we apply them to the online world, the situation starts to change a little bit. So border searches. It's presumptively reasonable that the federal government has an interest in preventing contraband from being brought into the country. So when you come from a different country and are entering the U.S., Customs and Border Control, they're allowed to open up your bag, take a quick look around, make sure you don't have a bomb, make sure you don't have drugs. Seems reasonable. Those are things we don't want brought into our country. Search incident to arrest. If you get arrested, the courts have decided that law enforcement has a right to search you for two primary reasons. One, to protect officers. If you get arrested, they want to pad you down and make sure you don't have a gun on you. They also want to make sure that you don't have any evidence on you that you might destroy if they're not paying attention to you. So those were the two exceptions for search incident to arrest. And then there's plain view. If officers are otherwise doing something legal, for example, they get a search warrant, they come into your home, and they're looking for drugs. If they happen to notice a bunch of automatic rifles on your table, they're allowed to notice them. They're allowed to confiscate them. They can take notice of them because they are in plain view while they're doing something else legal. And then there's searches that only reveal illegal activity. They've decided that you don't have a right to privacy in illegal things. And where this usually plays out is in what's called dog sniff cases. So there's drug dogs that are very carefully trained to only bark if they smell drugs. And it's been presumed reasonable for officers to take these dogs along a line of people and have them sniff you to see if you have drugs, because they're not revealing anything else about your person. So now, how about the modern context? Border searches. So normally people were just opening up a duffel bag, taking a look. Now whenever I travel, I'm carrying my laptop. And I don't keep my personal papers in my house anymore. All of my personal papers are on this computer. In fact, more papers than I could probably ever have stored in a house are kept on my computer. And it travels with me. So essentially, my computer is now the home of all of my most private documents. But under the current rules, whenever I enter the country, Customs has full reign to turn on my computer and search through all of the documents on it. There was just a recent Ninth Circuit decision affirming this. And this has caused a huge problem for businesses because they have confidential information. Lawyers have confidential client information on it, potentially clients that are in lawsuits with the federal government. They don't want the federal government to have these documents. Businesses may be carrying trade secrets that they don't want the federal government to have access to. And so the result is a lot of corporations now have policies they're not allowed to leave the country with their personal laptops. They have loaner blank laptops that companies are forced to do for all their business travel. And so what we want to think about is this reasonable? Are we protecting, is the trade-off between security and privacy reasonable in this case? And how can we find a better balance? And also, they're not only searching your computer, in certain cases, they're confiscating computers for weeks or months. So imagine you're doing all your business off your laptop. You come into the country. Customs says, we're going to have to take a look at that computer. A week later, you still can't do any work because all of your documents are on there.
Is that limited to just laptops, or can you do it with phones?
Anything, yeah, any electronic device. They can search anything they want as you come into the country. Yeah.
What about passworded laptops? Do you have to put in the credentials?
There's a huge debate right now as to their ability to force you to reveal passwords. They can probably try and crack your password, and it's unclear their legal authority to force you to reveal it. Yes, there's a whole bunch of companies that are actually offering systems where you can enter one password and it makes your laptop look like it's blank. Enter another password and it makes it look, and you get your normal desktop. So there's ways people are trying to work around it, and it's a completely undecided area of law right now. And then search incident to arrest. So it turns out almost anything you do is actually an arrestable crime. Anything you're getting a ticket for, they can technically arrest you. So traffic violations, most of the time you can be pulled over. And now, if I get pulled over, I may not have my laptop on me, but I have my smartphone. Gigabytes worth of data, and worse than that, access to all of my online materials, my passwords to Gmail, my backup files. This is essentially my key ring to all of my private data. And there's been a couple court cases now in the lowest courts trying to decide what level of access officers have to that. And the general decision is they have full access. There was a case in Florida where a guy was pulled over for, I think, speeding. He had his iPhone on him. The officer took a look at the iPhone. The background image happened to have a picture of him holding guns, which was probably a parole violation. The officer then went into his iPhone, found pictures of money, drugs, more guns, him and his girlfriend in various states of undress, and thousands of personal photos. This was all incident to just the arrest. This is an area I've been doing a bunch of research on, and my general argument is in an arrest, you should secure the devices. We should separate out seizure versus search. So it's one thing, if you get arrested, yes, officers have a legitimate interest in preventing the destruction of evidence. So they should turn off your device. They should in some way prevent a remote wipe. They should confiscate it from you. But then they should go through the normal warrant process where you have to go in front of a judge and convince a judge that there is a reasonable cause to search the phone to find specific evidence of a specific crime. The plain view exception. What does plain view mean on a hard drive? So if you go into someone's computer looking, for example, of tax fraud, okay, so that means you need to look at text files, maybe you need to look at some email, Excel files, Quicken. Well, the person might have received a fax, a digital fax, so now you need to look at image files. And then maybe the person was clever and are trying to hide files, so maybe they put fake extensions on the end of their files to try and hide it. So pretty soon, law enforcement has a really good argument. They need to search your entire hard drive for this one specific crime, and that may reveal the evidence of lots of other crimes, but it also gives them free rein to go through all your personal files. Maybe you're a political organizer. Maybe you're a political dissident. It exposes all sorts of personal information about yourself. And there's actually been a recent case in the Ninth Circuit. You all may have heard of the Balco scandal. So that was where a whole bunch of professional baseball players during the steroids debate were brought in. They were drug tested. It was supposed to be anonymous. The testing center was only going to report what percentage of professional baseball players were using steroids. The government got a search warrant to go in and seize the records for 10 specific ball players that they thought were illegally using steroids. When the government did that, they seized the hard drives that had the records of every ball player that had been tested, along with hundreds or potentially even thousands of other people were all intermixed on there. And they proceeded to claim the plain view exception to recognize all of that evidence and then in an attempt to bring charges against all those people for illegal drug use. And fortunately, in this case, the judges didn't like it. Judge Kaczynski, the chief judge of the Ninth Circuit, came up with a whole new set of guidelines for doing searches of hard drives that involve having a neutral third party do the search and only hand over information that was authorized under the warrant. This case will go to the Supreme Court. It hasn't been accepted yet, but it's one of the most controversial cases that's come out recently. And so there at least is some judicial attention to the issue. But it's a really hard case. We want law enforcement to find people doing illegal activities. At the same time, we want to protect people's private papers. And then the other area that complicates this a lot is something called the third-party doctrine. So there's a rule in Fourth Amendment doctrine that says if you've taken your private papers, you give them to someone else, you no longer have a privacy interest in them because you've exposed them to a third party. And so what this means is if I keep money in the bank,